pursuant to Rule 12 points. No one said the wrong number. Court pursuant to Rule 12.2 has issued an order for a competency exam to be performed by Dr. Locke to determine your competency to stand trial. The court has reviewed numerous pleadings that you have filed, and it appears that you may or may not be able to competently understand the nature of these proceedings. Now, you were scheduled to see Dr. Locke, and I was notified that you did not appear at that time. And that's why the court asked you to appear, ordered you to appear this morning, so that you would understand that that is a court order for you to appear for the competency exam. We have rescheduled it for July 8th at Dr. Locke's office. I'm sorry, at 7 a.m. It is at 7 a.m. At Dr. Chris Locke's office. And we will mail a copy of the order to you along with his address. If you do not appear at that time, that could be considered a violation of the terms and conditions of your bond. Now, the court doesn't want to have to violate the terms of your bond, but a competency hearing can be ordered either at the request of defense counsel, the state, or the court. And the court is concerned about your competency in this matter. Do you understand?
Do I have proper standing to speak, Your Honor?
Yes.
If it would please the court, Your Honor, I'd like to place my status on the record.
You may proceed.
I'm making a special appearance in behalf of the beneficiary and executor of the Robert E. Henderson estate. Also, Your Honor, I'm claiming common law jurisdiction. Also, Your Honor, according to 1951, the Power of Appointment Act, I have the right and the obligation and the power to appoint you as trustee to the estate, Prosecutor Stanley Alexander as trustee, and the clerk of the administration as trustee to the estate to settle the debt and close out this account, and that 160681 and 160682 be dismissed with prejudice, and the remaining portions of the beneficiary and the proceeds be returned to the beneficiary.
Your objections will be noted for the record, Mr. Henderson. The court cannot and will not grant your request. These are criminal proceedings. We are not in chancery. This is not an estate matter, as there's no one who is deceased. The circuit court does not have jurisdiction over chancery proceedings. That is the reason, and what you have stated is the reason why this court has ordered you to submit yourself to a competency exam. Okay? All right. So, having appeared today, the court finds that you have applied with the issue of the show cause. The court is satisfied that you understand that you are to appear for the competency examination at the office of Dr. Chris Locke on July 8th at 7 a.m. You will receive a copy of the order with the address for Dr. Locke's office. If you fail to appear, the court could consider that a violation of the terms and conditions of your bond. Do you understand?
Do I have standing to speak, Your Honor?
The only question asked was, do you understand?
I'm asking you, Your Honor, do I have standing to speak?
No, you do not, but you can answer the question either with a yes or a no.
Well, Your Honor, I'm not an attorney, I'm not a bar member. I really don't understand the question that you're asking me. But do you bring the claim to my estate?
Mr. Henderson, while this matter has been pending, this court attempted to appoint you counsel to assist you. You refused to cooperate. The prior two judges who have been assigned to this case also attempted to provide you with counsel to assist you. You have always rejected that. So you are considered a pro se litigant at your own request. So to now come before the court and make issue with the fact that you don't have an attorney and you don't understand these proceedings makes a mockery of what this court is trying to do. That is why the court attempted to provide you counsel to assist you with understanding legal terms. They would not try your case. That would still be your responsibility. And you have declined that assistance every time the court is provided to you. And that is why the court is concerned along with your rambling, that you may not understand or be competent to proceed further with these proceedings.
Do I have standing to speak, Your Honor?
I'll ask you this question. Do you want the court to appoint you counsel to assist you with these proceedings?
Do I have standing to speak, Your
You
Honor?
can answer the question yes or no.
I don't quite understand. I'm not an attorney. I'm not a bar member. And I really don't understand the question that you're asking. But I want to have due process, and I'm being denied the right to due process. And I think that that's fraud upon the court. I've asked you several questions, Your Honor, and you failed to reply. I asked you, did you bring the claim to my estate?
Mr. Henderson,
I asked you a question, Your Honor. You're asking me a question, so I'm asking you a question.
all right, Mr. Henderson, I'm going to say this, and this is the only thing I'm going to say. When you appear before the court, it is not a two-way conversation. You do not get to ask the court questions. You can only respond to the questions that are asked of you. Now, at this time, the court has issued an order for you to appear on July 8th at 7 a.m. at the office of Dr. Lott for forensic evaluation. And that will conclude the proceedings in this matter. You are now excused.
Do I have standing to speak,
No,
Your Honor?
sir, you are now excused from the court. You may leave. All right, next on our docket, the state of Mississippi versus Zebulon James. You may be excused. I think Mr. James is going to bring us shortly. Let's take a recess until Mr. James arrives.
All right.